First case to come before the court today is State of Ohio versus Brionna. This is a state's appeal, so Mr. Brionna, you will go first. And just let me know how much time you would like to reserve for rebuttal, if in fact you want to reserve any. The arguments are being visually and audibly recorded, so keep your voice up, stay behind the podium, and I will do my best to watch the time for you. I don't think it has any applicability in this case, but don't use the names of any children or victims. We have read your briefs and we're ready to begin when you are. It's not. Huh? I'm not getting this. I can't tell you. We did.
Yeah.
I've come to rely on that.
You're better off relying on that than me, although it is the same. All right, whenever you're ready.
All right. Thank you, Your Honor. Good morning, Your Honors. Brian Brower on behalf of the State of Ohio. I would like to reserve 5 minutes for rebuttal.
All right.
The trial court in this case determined that Trooper Fowler lacked probable cause to believe that the defendant operated a vehicle while impaired. That decision was incorrect based on the totality of the circumstances available to the officer. And before I go into what those totality of those circumstances were, I think it's important to reiterate, probable cause is not an incredibly high standard. It's not reasonable doubt, it's not preponderance of the evidence, it's not more likely than not. It is just enough to have a person of reasonable prudence in the belief that a crime has occurred. In this case, Trooper Fowler had that. He observed the defendant driving her vehicle late at night, past him without dimming her high beams. That is while that is probably not the same thing as someone having a traffic accident or crossing over the double yellow line, it is still a failure to operate your vehicle properly. It's in some ways like a distracted driving indicator. They initiated the stop, and at which point they detected odor of alcohol and burnt marijuana coming from the defendant. The defendant exited the vehicle, and that odor continued throughout the stop. Once she was out of the vehicle, they performed a number of the field sobriety tests that are standard for NHTSA to detect alcohol consumption and impairment. During those tests, Trooper Fowler observed 4 out of 6 signs in the HGN for intoxication, 4 out of 8 signs during the walk and turn test for intoxication, and 3 out of 4 signs during the one-legged stand of intoxication. The 4 out of 6 signs, as I noted in my brief, during the horizontal gaze and nystagmus test, courts have noted that creates the inference that there's a 77% chance that a person's BAC is higher than 0.1. That is not 0.08, 0.1. So it's more likely than not, based on that one test, that the person's alcohol limit is above the actual per se limit in the state of Ohio. But there are also the other indicators from the test.
Mr. Bremer, let me ask you a question regarding the field sobriety tests
Yes.
in general. They were challenged in the suppression motion, is that correct?
There is some challenge to, there are a number of issues raised in the suppression motion. Trial court only addressed the probable cause aspect.
Are we to infer from that, or can we even infer from that the trial court found the stop itself to be acceptable and the field sobriety test to be substantially complied with, and then jumped to the other issue, or is there a problem there?
I believe the trial court did not find any, did not assert any issues involving how the officer conducted the field sobriety tests. And I would say also it's not entirely clear from, I would say based on the actual motion that was filed, that there's actually an issue of whether they were sufficiently preserved, those challenges, even under Code of Lippe. The fact is, there are a number, the motion to suppress raises a number of different issues, and the only issue that ended up ultimately getting decided here is the probable cause aspect of it. And since there was no finding of that the officer failed to actually comport with the NHTSA manual, I don't think there's any basis to actually use that as a reason to reverse at this point, or affirm, I would say. The evidence, and then in addition to those field sobriety tests that he performed, the trooper Fowler also performed a number of tests related to marijuana impairment. These other tests are not signs of alcohol impairment, they're signs that he does them during stops that there's a concern of marijuana impairment. Those were the modified Romberg test, the vertical gaze nystagmus test, the alphabet test, and also lack of convergence test. In those tests, there was only real signs of impairment during the lack of convergence test, where the eyes did not converge, and that is indicative of someone's marijuana impairment, according to the officer. In addition to that, when he looked inside the defendant's mouth, he observed a cream coating on her tongue and raised taste buds, which he testified is also part of his training for narcotics interdiction, that is a sign of marijuana consumption use. So based on all this evidence that was before the trooper had probable cause to believe that she had operated the vehicle while she was intoxicated, but in addition that she had consumed marijuana, which would have definitely increased the amount of the impact of the alcohol. In addition, he had reason to believe that she was impaired from the marijuana based on lack of convergence test. However, even excluding those marijuana tests, which again only go to whether or not she was impaired from marijuana, the HGN, the walk and turn, the odor of alcohol, the one-legged stand, those all go to whether or not she was intoxicated at the time of the arrest. And in this case, they also was a driving violation, which was not a mechanical one. It was not like a headlight was out or a tail light was out or had something not to do with the driver. This is the driver failed to actually comport themselves in a manner that is required by state law. And so it's an indicia of her being intoxicated, or at least impaired or distracted or something, which would go to the reasons why there would be reason to believe that she was impaired by alcohol in this case. One of the issues that's raised in the appellee's brief is that, well, the trooper didn't arrest her at the moment that he had finished the field sobriety test for alcohol impairment. Well, there's no requirement under federal law, Ohio law, or any other standard to arrest at the moment you have probable cause. To do so would actually be against public policy for a number of different reasons, not least of which is that you're asking the officer to make an on-the-spot determination about whether or not they have enough at that moment in time, and maybe they're going to cut something off their investigation too early, and more evidence will be excluded than should be under the law. Officers are permitted to continue to investigate the crimes. In this case, for example, once he did the HGN, as I just said, that would give probable cause that she had driven the car while intoxicated. Well, does he need to stop doing the field sobriety test the moment he does the HGN? No, like you do all of them. You continue onward and you see what you can learn from the investigation. And similarly, even assuming that at that moment the officer himself, for whatever reason, did not believe he had probable cause, the test is not his subjective belief. The test is an objective one. Did the objective officer have probable cause? And the answer is yes. There was probable cause based on the driver violation, the 4 out of 6 on the HGN, 4 out of 8 on the walk and turn, and 3 out of 4 on the one-leg stand, and the odor of alcohol to believe that the defendant had operated her vehicle while she was intoxicated and was impaired. For that reason, the officer had probable cause to arrest her. And in addition to those facts, the officer also knew that she smelled burnt marijuana, had green coating on her tongue, and had raised taste buds, all of which are physical signs of marijuana use. And again, it was burnt marijuana. It was not like just a regular raw marijuana smell. This wasn't someone who was coming home from working at a grow site for medical marijuana or a medical marijuana dispensary. It was someone who had at least been near someone who had been smoking marijuana, if not been, and based on her tongue, had actually been smoking it herself. These are physical signs. This is the equivalent of asking someone if they ate ice cream and you see ice cream smear over their face, and then they say, no, I haven't been eating ice cream. Well, there's clearly signs that you have been, and why are you lying to me about it? There must be some reason that you want to misrepresent that, and in this case, it would be the fact that she was impaired from the alcohol and marijuana use. And that's why we're talking about why her denials, despite the physical evidence, as being another indicator of her impairment when she was driving the vehicle on the night in question. And
so you're saying because she didn't admit to smoking marijuana?
I would say, I'd say yes. Like it's one of those things where I know that the people who drive impaired are definitely in a catch-22 in the sense of If they admit to smoking and admit to drinking, well, that's evidence of them drinking. But if you're like just absolutely, if you just reek of alcohol and you have bloodshot eyes and glassy eyes and slurring your speech, and you say, no, I haven't been drinking, officer, like, well, that's indicative that you know that you're over the limit, because otherwise you just say, no, I had a drink, I don't know why I'm acting this way. Like, you would have.
Seems like a clear violation of self-incrimination too.
Well, self-incrimination does not apply at the point of the stop. You have a right, you may have a right to not incriminate yourself, but that doesn't mean you have a right to lie about it. And in this case,
So she just should have answered.
I mean, that would be one way to do it. You'd not be able to force her to answer that question.
I'm going on a tangent, but I wanted to ask you, following up with Judge Callahan's question to you earlier, not just not deciding, the prior, like, was the stop too long, was there reasonable suspicion, all those things, but you also are arguing throughout your briefs that the court really didn't consider the totality of the circumstances. But that seems like, by saying that, like you said, you didn't mention the tongue, you didn't mention, the taste buds, you didn't mention this, you didn't mention, doesn't that really go more to like the court hasn't thoroughly analyzed this? Or at least given us the reasons?
I'm familiar with this court's precedent on the fact that you will not decide the issues in the first instance. And if the court were to decide that the court failed to properly apply the probable cause standard, that could be a basis to reverse the court's decision. And in this case, our concern is more that we want to make sure that the standard gets applied properly, and that in this case we feel there's probable cause, but we want the standard to be applied properly in this case, and if this court decides that the court failed to do that below, that'd be a reason to reverse. And I will reserve the right to that. Thank you.
Thank you, Your Honors. May it please the court, Attorney Angie Kelly on behalf of the appellee, Brionna Johnson. We would ask the court to affirm the decision of the trial court in granting Ms. Johnson's motion to suppress. It's our position that there was not probable cause to effect an arrest, that the court did do a totality of the circumstances analysis, and that therefore made the proper decision. Just very briefly in regards to the primary argument that I saw in the state's brief is that he didn't mention every single fact that the state wanted him to, or the state presented, and that's why he didn't look at the totality of the circumstances. I disagree. I mean, there's no precedent or law that says that the court must lay out every single fact presented and discuss why or why not they found that to be credible. The court has the ability to view everything as a whole and determine whether or not they felt was sufficient or not sufficient and what the basis of their decision was. It's quite clear that the trial court applied a totality of the circumstances standard. He specified that in his order and felt that it was insufficient.
You see the wheels turning.
I do, I knew what was coming, yes.
I'm just trying, excuse me, I'm thinking of our standard of review on the suppression. And did the trial court properly determine the facts, and then did it apply the law correctly? Those are my words, not the exact words. But how are we supposed to know if the trial court properly determined the facts, if the trial court omitted a lot of the facts? I mean, your argument would be that the trial court didn't find those to be important. The state's argument would be the trial court disregarded things that are important, but we don't even know what all the facts were based upon the trial court's findings. We know them more from your briefs.
It is a very limited finding of fact.
Not your fault, but I'm just
No,
wondering out
it is
loud.
very limited, and, I guess my position, our position would be that, it's fair to say some of it was probably not considered to be in dispute. I mean, there's no dispute that she committed a traffic infraction. There's no dispute that there were some indicators on at least the 3 tests that are NHTSA approved. It's whether or not that was sufficient, and that's my understanding of the standards that the court must accept the trial court's finding of facts. If it's that limited, then I don't know. I'd say probably that's what you base off of.
It's what we all have. So.
That and transcripts. I mean, my impression, and I'm not the trial court, so I'm kind of speculating, I felt as though the trial court relied heavily on the video. He specifically mentioned that he watched the video. I think it might even say more than one time. and that he relied upon that evidence, and that evidence, of course, is before this court and available for review. I can say that for myself, because it was a fairly limited transcript, I reviewed the video multiple times in drafting to try to get an appreciation, and I would urge this court to review the video. You know, in this day and age where we have that type of evidence that's available to us, I certainly think that it was prudent of the judge to consider that in a big way, because there's no question as to what is happening. It's presented in evidence, and in a case like this one, you know, I would certainly disagree with the state. And was there a traffic infraction? Yes. I would say it's de minimis at best. I can't see how failure to dim your headlights is something that would be indicative of impaired driving, something I've done on a number of occasions just because I forget that they're on. I think that's human error is what it is.
Convinced people would say it's indicative of poor judgment. I'm just saying what they say.
So, and I don't think there's a dispute, I don't feel as though this traffic infraction is something that tends to lean towards a finding of probable cause. I think also too that the court should give some consideration to the fact that there were a few discrepancies in the testimony, and I think that lends towards the credibility of the trooper that was testifying. If your honors watched the video, it was definitely drizzling, at least at the start, his wipers were on when the video clicks on. His testimony was that it was a clear evening. So obviously there's some memory issues there. He also testified that she made errors in the alphabet test. There are no errors in the alphabet test on the video, it's quite clear. In addition to that, the other thing that I would notice is that in regards to the credibility and the training of the trooper in this particular instance, they did take judicial notice of the 2018 NHTSA handbook, court did. However, his testimony was that he had had no training since 2016. So it is possible that there's new information that he doesn't have available to him.
Wouldn't that be nice to have those findings? Actually, there's no.
It would, wouldn't it?
Actually, there's no real findings, are there? I mean, the court just kind of relays what testimony was, but it doesn't say, here, I find this.
I think he just did a very brief statement of facts as to what he must have thought was the most relevant in his determination.
Right, but it doesn't necessarily identify them as findings.
Not like specifying, like placing this fact goes to this area, no. He just broadly sweeps with a totality of the circumstances. So I will acknowledge that. However, I feel as though if this court reviews, you know, the facts and the totality of the circumstances, that his decision was in fact right. I mean, we have a very de minimis traffic infraction. We have some indicators on the NHTSA approved tests, but in addition to that, some of the things that you generally see with impaired driving is slurred speech, bloodshot eyes, people stumble a little bit, that kind of a thing. If you watch the video in this instance, she gives no indication of any of that type of behavior or conduct that would be consistent with somebody who's under the influence of either alcohol or marijuana. You know, I think that I really think the video is crucial in this decision, I do. Because as you watch it and you look at the entire circumstances surrounding it, I think the court considered that because we had these factors. The trooper did not decide at that time to effect an arrest. I understand that the law says that he doesn't have to do it the instant he sees it, but if he felt that she was severely intoxicated once he completed the NHTSA approved test, he certainly could have put the cuffs on her and taken her into custody. We'd be in a little bit of a different situation, but he proceeded to do additional testing, much of which has no scientific backing.
How would we be in a different situation if he stopped after the field sobriety test?
I actually think that the continuation kind of helps with the analysis of the totality of the circumstances, because some of the additional testing that he did, she passed.
But you either had enough indicators on the field sobriety test or you didn't.
Well, I think that if the officer was basing his judgment on something that was that firm, that it would be harder to argue that, but to me, what that says is that he wasn't quite so sure. And I do believe that although those tests, he obviously must consider those tests to have some indication or some bearing, and as he continued testing her with the unapproved test, she passed almost every single one of them, which I think that when
I'm sorry, go ahead. I'm sorry.
I mean, I think that when you're looking at it overall, that actually supports the court's decision.
But that was from being under the influence or impaired by marijuana use.
Some of it, yes, and honestly, I don't know that it was very clear to me in the transcript which one they were actually saying she was under the influence of. It kind of sounded like they're trying to allege both.
So, to me, impaired driving is impaired driving.
Well, but the marijuana, I think you point out that they weren't, it's approved because, so you could have somebody under the influence, obviously, of alcohol and impaired, and have smoked marijuana but not be impaired by the marijuana. So maybe that's the reason why the officer felt, that the trooper, I should say, felt that he had to look at both of them.
Especially in light of the fact that he smelled marijuana at the time of the stop.
He did. I know one thing, understanding it can't in first impression, but given this, I know that the state was hard getting on the idea that it was burnt marijuana as opposed to raw marijuana, and at this stage, I don't see the difference. He didn't do any questioning of this person as to whether or not she may have a medical marijuana card. Just because the scent lingers for a little while doesn't mean there's any indication as to when that took place, if it took place, or whether or not it was legally done.
Are you permitted to, even if you have a medical marijuana card, you're still not permitted to drive under the influence, are you?
I don't believe so, no, but that doesn't, with all the additional issues surrounding marijuana and hemp that are taking place right now in the state of Ohio, I certainly think that these things require further exploration, because if somebody could smoke their marijuana earlier in the day and no longer be under the influence, but it's still gonna cling to their clothing and their hair, that scent can still be prominent. Doesn't mean that she's at that time. And I have not been able to find any information. NHTSA doesn't approve any of those tests, because right now, as it stands, NHTSA doesn't know how to verify whether somebody is under the influence of marijuana when they're driving. There's some testing being done in different jurisdictions, and officers are trying to rely on it, but there is just nothing yet that has any scientific backing. Which is kind of a catch-22, and technically it's illegal to drive impaired, but it's almost impossible to make that determination effectively. My impression is that the trial court here didn't consider any of those tests primarily. The only one they brought was the alphabet test, and I think he brought it up because he noticed the difference between the testimony and what was on the video, that the testimony was that she failed and that she did not. So, understanding that this court certainly can reapply the facts to the law and look at that as a de novo standard, we believe that the trial court made the correct decision in this, and I would urge your honors to watch the video and take that into consideration when reviewing and determining whether or not to affirm that decision. Outside of that, unless there's any questions, I would rest on my brief.
All right, thank you.
Thank you.
Thank you, Your Honor. I just wanted to touch on a few issues that were raised during Eppley's argument. I would say when you watch the video, we didn't bring this up in our brief because there's no real discussion of it during the testimony, but to say that she exhibits no signs of impairment during the video is not entirely correct. She's I would describe her as being a little bit more bubbly during a police than it would be typical during a police stop, which I would describe as someone being a little bit under the influence of marijuana, possibly. But again, that's not the idea that there's no evidence is not really supported by the video. There's some indication that she's under the influence of something during the video, just given how kind of, again, she doesn't seem to exhibit too many signs of being that most people exhibit during traffic stops, I guess would be the way I describe it. When I brought up the medical marijuana, I was saying that there's, raw marijuana can have a number of legal reasons you have that smell on you, which would be, again, working at a grow site, working at a medical marijuana dispensary. And the idea that if you had a medical marijuana card, you wouldn't bring that up as an explanation for why you smelled of burnt marijuana seems, you would do that. That's a great example about why when she keeps saying, no, I didn't smoke marijuana, no, I didn't smoke marijuana, despite having a raised taste buds, green tongue, and smelling like it. Well, that seems to indicate that she knew that she had done something wrong involving marijuana, as opposed to saying, no, I have a medical marijuana card, I smoked it hours ago, I'm not under the influence. Like, that would have been an easy explanation, but she never offered that up, and so that's why the repeat denial seems to indicate the consciousness of guilt about the whole issue. The court did consider another one of the tests, not just the alphabet test. The court brought up the modified Romberg test, which is a test where they tip their head back and try to keep track of time, to see, for about 30 seconds, and if you're within 5 seconds of that, you don't show any signs of impairment according to the test. She was within 5 seconds, the court brings that up. But I would say, again, the officer testifies he only did those tests because of the burnt marijuana smell and the raised taste buds and the green coating on her tongue. They were not related to the alcohol, they were related to marijuana use. And he talks about that in the transcript about why he did those tests. These tests don't go to whether or not she's impaired by alcohol, they go to whether or not she's impaired by marijuana. So even assuming she passes the marijuana tests, they don't undercut the field sobriety tests that he did for HGM, walk and turn, and one-legged stand. Furthermore, to argue that they're not scientifically reliable, well, that just means that they can't possibly undermine the other tests. Like, the other tests are proven to be scientifically reliable tests. If you're saying that we can't rely on the tests that he did for the marijuana usage, then they can't possibly undercut the totality of the circumstances for the alcohol consumption and the intoxication from the alcohol. Either they're reliable enough to detect marijuana, which is the only thing they go to, or they're not reliable and they don't affect the alcohol test at all. I would also point out that in this case, the court's journal entry, it does not have a section defined as findings of fact. It just does not have that. But the court does make statements that are not merely so-and-so testified to this, so-and-so testified to that. They are saying, this happened, this happened, this happened. Like, it says that they pulled her over for a traffic violation of failing to dim her high beams. Like, that is just a statement of fact in the case. And so the court is going through here, and while there may have been a better way to articulate this for purposes of the appeal, because there are findings that are getting made in the court's decision. And quite frankly, the court's findings are not really in dispute, except for the fact that the court only, like at one point, as we point out in our brief, the court says only 2 tests were done for the marijuana, but there were actually 2 other ones, one of which was lack of convergence, which showed that she was impaired. And the court does not mention that test at all in its journal entry here. And that's one of the things we brought up in our brief, is the fact that the court is disregarding a number of factors that actually were under dispute of the case. So we respectfully request that the court affirm the decision reverse the decision of the reference report. Thank you.
All right. Thank you both for your arguments. We'll take the matter under advisement, issue a written opinion in due course.